My name is Robert Laurie. I am the principal of Lucem Law Corporation, which is a law firm that specializes in cannabis and regulations surrounding psychedelics and other alternative medicines. On October 17th, legalization transpired and the Cannabis Act came into effect, replacing cannabis and the removal of cannabis under the Controlled Drugs and Substances Act and dealing with it solely under a new framework and legislation known as C-45, the Cannabis Act. Following legalization, it became very apparent that medical access was not adequately provided or accounted for under this transition. In fact, there have been a number of lawyers who recently were in Supreme Court of British Columbia on the dispensary test case, which was a constitutional challenge filed in response to the City of Vancouver's 62 or so injunctions against various dispensaries, some operating with, but most operating without a business license. And with that, the new government regime that was to come into place on October 17th, of course, provides for retail, but does not provide for any sort of medicinal access through a storefront brick and mortar retail store. You could still only obtain medical cannabis through Health Canada's licensed producer system, which is through mail order. However, given the undersupply of cannabis and difficulties surrounding the processing of licenses by Health Canada, it is estimated that the supply of cannabis will be in a deficit for at least a number of months, possibly a year, some pundits are saying. That is under the legal regime. However, the black market hasn't gone anywhere. And so you'll notice in Vancouver, if you walk up and down any of the major streets, you'll see that there are still a handful of dispensaries, or a good number of them, still open. Those dispensaries are arguably providing reasonable medical patient access in accordance with rights that the courts have identified in the 15 to 20 year litany of litigation regarding cannabis and medical access. Well, we're stuck in a situation now post-legalization where medical patients are not accessing medical cannabis. At the moment, under legalization, all a medical patient can access is cannabis flower and oil. They're not eligible, nor is there a facility or a procedure under the government program for edibles, concentrates, tinctures, etc. There's only provisions at this stage for retail cannabis surrounding flower and oil, which means what are medical patients doing in the interim? Well, they're continuing to vote with their feet, as they did in the Allard and Smith cases, by going to the dispensaries for product which the federal government plans to license possibly in a year. Well, if it's anything like the rollout of legalization we've seen, they may want to consider bringing that process forward quicker, because dispensaries will continue to provide medical access. Patients' conditions are not going to cease and wait for the government to come up with policy. So ultimately, now that we're legal, supposedly, you're going to see more civil disobedience around patient access. Why? Because unlike recreational access, medical access has to do with Section 7, which is a charter right dealing with life, liberty, security of the person. Versus recreation, there aren't the same rights as there is with medical access and issues regarding medicine and integrity of the body. So the government, by introducing recreational cannabis, I believe, has taken a lot of the wind out of their sails as to why cannabis needs to be regulated to the degree which it has. And unlike the licensed cannabis stores that we're seeing throughout a number of provinces in Canada, Dispensaries have been operating for 20 years. In fact, it's through dispensaries, civil disobedience, and medicinal patient access that we've even are in the place that we are now with regards to legalization. However, medical patients have been abandoned. The medical system looks like the government's just trying to replace it with a recreational system, which ultimately is not doing any service to the patients on a couple of fronts. Firstly, patients are having to pay more than they would normally be required to accessing cannabis in a dispensary. So LP legal cannabis is significantly more expensive. It's also a recreational product, which means there's taxes associated with it. Thirdly, well, it's not being treated as medicine. And so, like any other controlled substance that people access under the Food and Drug Act and medicines that, of course, are recommended by doctors, are accessed and treated in a very different way. But cannabis, unfortunately, because there are money and commercial interests so interwoven with this process of legalization, that what we're seeing actually is a recriminalization of cannabis. And so the ones that are doing well out of this process are the corporate government monopolies who are going public with market cap valuations greater than Canadian Tire in some instances. But what are they doing at the end of the day? They're providing and they have a license to provide a agricultural product that they're flogging as a pharmaceutical commodity, which maybe for now, because the market's blind and ignorant, will continue to generate these over-the-top returns. But as I see it, as more countries begin to nationalize and legalize cannabis for medical or rec purposes, what are they going to need Canadian cannabis for? It's like bringing sand to the beach. So again, before we start shipping our Canadian cannabis off to the European Union or Australia, we should ensure that there's an adequate supply for medical patients, because let's not forget that most of these licensed producers have gotten into the position of the market that they have through the assistance of the federal government. And at the end of the day, we pay the federal government with our taxes. So we should have a system that works for the people and the medical patients, as opposed to a revenue generation source and the commercialization of what should be an open source, public health regulated commodity. So have we legalized cannabis? Well, the answer is yes, according to the federal government, but my conclusion is no. And there's a lot more work to be done in this new era of legalization in order for patients to truly be represented and to truly participate in accessing cannabis. What I'm looking for at the moment is that, as indicated, I was involved with a 21-day scheduled charter challenge. We're going back to court in the next few weeks. And what we're looking for are medical patients who have been registered under the licensed producer system and who have participated in the ACMPR. We'd like to talk to those medical patients. Why? Because they were accessing cannabis from an LP prior to legalization, which also meant they must have been subsidizing or supplementing their LP cannabis from dispensaries. We'd like to learn about that. We'd also like to learn what these type of patients are doing in the last few weeks, now that there is a drastic shortage of the cannabis available from licensed producers. Failing that, if you still have questions, well, I'm always available if you wish to reach out to me or my team at Lucem Law Corporation. We'd be happy to do our best to facilitate your questions. And I can be reached directly at 604-218-1084. So looking forward to hearing from you, and that's my thoughts on legalization and what's in store for medical patients. I'm Robert Laurie.
Thank you very much. Yeah, it works.